Now we've taken a basic introduction to looking at the definition of land law in the UK and the kind of things we're going to be discussing when we look at land law. What I want to do is talk about the history of land ownership in the UK and how this has really developed effectively over 1,000 years of English history, and why these historical implications still have a lot of relevance today, because effectively the guiding principles, the basic principles of land law go back to William the Conqueror and beyond, and so we have to really have only a basic understanding of these historical updates that have taken place before we can look at the legal premises of land law, things like registered land, unregistered land, freehold, leasehold estates, these kind of things. So, as we established in the last lesson, land law can be described almost as like a subset of property law. It's a very specific type of property law, where the property is land, and we discussed in the last lesson that the nature of land as a property, as something that you can own, or at least effectively you can own, is something that's very different to, say, owning a laptop or owning a phone. There's a huge number of differences. If you want to go back to the last lesson, I'll link it in this video, because effectively the reason why we have land law separate to property law is because the law regulating land is very different to the law regulating other types of property. And in reality, these regulations come from history. So the history of land law informs a lot of the concepts that we still accept today. So it's important to spend some time discussing how the history developed land law, rather than beginning by looking at the legal principles themselves. So the first thing we should know is that we do not own land. We own, quote, estates and interests in land. And by we, I mean, people who are not general public, so general population, people who are not the monarchy, effectively. Okay, so this was briefly touched on in the introductory lesson, but effectively the historical theological interpretation of land is that land is something that was a gift from God. Okay, and thus this idea of land being a gift from God informs the interpretation as to who owns the land. Now, traditionally, land is a gift from God to the Crown of England. So, the Crown of England. And this relates to a number of guiding principles within the theology and the relationship between God and the King or Queen of England. And, ideas such as the divine right of kings. So, the divine right of kings. Now, this is the general theological interpretation, and this theological interpretation existed before the 1200s. However, we start to see it more and more codified following the 1200s. And so, as we see this interpretation develop, we see that the monarch go from the king of the English people, the original interpretation being that the monarch was the king of the people. Okay, we go from that interpretation to the interpretation that the monarch is the king of the land, king of England. Okay, and now that little shift in the nomenclature and the interpretations of how we understand the relationship between the king and between king and England is informed by the fact that traditionally the land was a gift from God, and this gift from God was gifted to the monarch. And so since the 1200s, all land effectively belonged to the crown. However, we'll note that it should be noted that this there isn't a specific cut-off date where you have this kind of interpretation taking place. I can't name you a specific time in history, because the history of land ownership is something that's been a very gradual process. And one of the processes that take place within the history of England and that date even before the 1200s, is the concept of feudalism. And this is something that was imported from Europe following the Norman conquest of England. So we know that William the Conqueror came to England in 1066. So it dates back even a few hundred years before this concept of England. And the system of feudalism began to develop. And we can understand why feudalism developed because of a number of factors. So the first factor is that even before the 1200s, the crown was seen as the sole owner of land. Okay, it's just in the 1200s and beyond we start to see this this change develop linguistically as well. The second thing we can mention is that when we're talking about creating economic progress, creating wealth from land, this required labour, and this still requires labour today. However, back in following the Norman conquest and the medieval period in England, labour was an inefficient task. We didn't have any kind of coordination as such or industrialisation that took place. So labour was a labour-intensive task, and it was very inefficient. As such, what the king would do would be to allow people to use and occupy his land in return for the performance of certain services. So you can toil the land that you're allowed to live on the land that you toil, that you work on. And it should be noted that it's very important that in this kind of relationship between the king and his people, and the king almost granting permission to live on the land that they work in return for for a certain service or for certain goods, a transfer of land never took place. So the king still owned the land that they were working on. So the king still owned the land. The king still owned the land. I mentioned king and not king and queen because at the time the vast majority of monarchs in England were kings. There's some historical possible it's the debate as to who the first queen was, but arguably Mary the First, as late as the 1500s, was the first queen of England. So we're talking about just kings. And this process, getting back to the law, this process of almost allowing permission in return for a service was called a tenure. So you were granted a tenure. And this doctrine of tenure, this kind of principle that the doctrine of tenure, you are allowed to live on the land that you work in return for certain services, this sort of contractual relationship between the king and his people, was not just limited to the king and his people. So there wasn't just a limitation between just the monarch and this service being done to his subjects. Once the doctrine of tenure applies between the monarch and some other person, those who received that tenure from the monarch could then offer a tenure to somebody else. Okay, and this was known as a system of subinfeudation. So we have a system of subinfeudation where it's effectively like a pyramid scheme. So you have the monarch at the top who offers and grants a tenure to someone down below, and they grant a tenure to other people, and then so on and so on and so on, to the point where we have this almost spiral of tasks and services and economic relationships between all of these different people. And at no point in any of this system of subinfeudation do we see any land transfer from the monarch to the people. It is just granted a tenure to that land. And so that is a kind of thing that informs the modern day interpretation of land ownership. Today, all land is still owned by the Crown in England, and thus one's relationship with land shouldn't be seen effectively as an ownership. You don't own the land, no matter what kind of rights, whatever kind of proprietary rights you have over the land. You don't own it. The relationship with land should be one of either an estate in that land or an interest, unless you're the monarch. And if the monarch is watching, then this doesn't apply to you. But the for anybody else, for the rest of us, mere mortals, the relationship we have with land is not one of ownership, it's one of an estate or an interest. And we're going to get into them obviously in a lot more detail, because these are the legal relationships that we're going to be talking about. So the legal relationships. Not only are we going to be talking about the legal relationships and the proprietary rights that you have depending on the type of interest in land you have, or estate in land, we're going to be talking about the types of land that exist, the ideas of registered land and unregistered land. So when we talk about estates in land, I'm just going to very quickly, because this is what we're going to turn on to first when we're talking about land ownership in quotation marks, in proprietary rights in land. Okay, I'm going to try my best to not say land ownership, because for some cases, i.e. a freehold estate, then what you're doing is you've been given de facto ownership of a piece of land. However, you're not legally owner of the land, because the owner of the land is still the monarch. So like I've just mentioned, you have different types of estate in land. Oopsie daisy, I've just moved this around. Let me move that back. Just move. Oops. There we go. Anyway, so what we do have is two broad types of estate in land. So you have a freehold estate, or you have a leasehold estate. Now there are obviously different types of subcategories that we're going to talk about as well when we go into a lot more detail on these. But as the sort of broad interpretation, you have a freehold or a leasehold estate. And when we talk about estates, okay, specifically a freehold estate, you can be understood as having what we call de facto ownership of the land. Okay, for all intents and purposes, you own that land, but it's still legally, like I mentioned, the land is still historically owned by the Crown. Holding an estate in land, whatever the kind of estate in land, okay, gives you what we call a quote slice of time during which you're entitled to possess and enjoy that land, and the relative sort of temporal distinctions will distinguish the type of estate. So the type of this slice of time is determined by the type of estate you have, and so therefore, and this also gives you grants you other kinds of rights, and so therefore, an estate in land is very important, and which when we move on, following these lessons, we're going to talk about the different types of land that exist, things like registered land, and we talk about things like the land registry, and then things like unregistered land. But then when we move on to talk about proprietary rights in land, proprietary interests, things like an estate or an interest itself, we're going to start by looking at estates, and we're going to start by looking at freehold estates.